Morning, Milas.
Yes.
Milas, I'm appearing in the first matter, Milas. I'm appearing for
Just a minute. Let the matter
Sure.
be called. Let the matter be called.
Very well, Milas.
Oh, you want
My
to
apologies.
mention or something?
No, Milas. No, my apology. My was item 1. That's where I Milas.
All right. Yes, call the matter.
Orders, item numbers 1 and 2.
Yes, Milas. May I, Milas? Subject to
Yes.
my last permission.
Yes.
Milas, I appear for the applicant here, Milas, the department, PWD. Milas, I had moved an application for modification of my lot's order of 8th March 2024 in view of the subsequent events and the facts, Milas. And thereafter, Milas, during the pendency of this modification application, the opposite party number 1 has filed a contempt, having the full knowledge and notice of it. And that also was listed on 14th October, Milas, or before Honorable Mr. Justice Sharma, and the notice has been issued. So they are basically precipitating the coercive action, Milas. So that necessitated a filing of a stay application till the pendency of this modification application before my lords, Milas. The reason was 2, Milas.
Which is
Yes,
the
Milas.
stay application?
Yes, Milas. This is second one is the stay application, Milas.
Number? What is the number?
And number, Milas, I'll give my loss the number. I have it right now, Milas. The application number is Milas. If my loss can just bear with me for 1 minute. It is Milas 195 of 2025, Milas.
This is stay.
Yes, Milas.
The 168 is regarding modification.
Modification, absolutely, Milas.
Okay. You're
Only
seeking.
I'm praying, Milas, till the pendency. PWD is not going to run away because now they have invoked and they have filed a claim of 300 crores, Milas, which they did not have when my laws passed that modification order. And I'll substantiate, Milas, how they are trying, both of them, contractor and the subcontractor.
No, just a minute. When did we pass modification order? I don't think.
8th March, if my lords has my application, my main modification application, the order is on page 28, Milas.
In which case, IA 168.
Yes, Miller. The writ petition, the order by my lords on 8th March in writ petition number 80 is on page, it starts from page 27 of my modification application, Millers, if my lord says it.
Application. Page number?
27, if my lord has of my modification application.
27 there, that's correct.
That's the order, order and direction my lords had passed on 8th of March.
Correct, but why do you say it's a modification order?
No, no, Miller, this was the order passed.
This is an order by which the writ petition was disposed
of. Thereafter, I filed my modification application, Millers, in view of the subsequent application.
Which is that application?
168, Millers. 168 is my modification application.
Correct.
Yes, Millers.
So, any order has been passed in that?
My laws have issued the notice to the other side, Millers.
Notice, that's all, isn't it? There's no such kind of...
Yeah, and Millers, because they, I had served them immediately on 25th of, on 27th, Millers, and having a full knowledge, they filed a complaint, contempt against me on 8th of October, on which the Honorable Mr. Justice Sharma was pleased to issue notice on 14th October. That I also have annexed with my stay application, Millers.
No, just 1 minute. See, we are at page 27.
Yes, Millers.
The writ petition was disposed of by this judgment and order dated 8/3/2024.
Right, Millers.
Then what was the direction in that judgment was that...
May I read, Millers? May I read?
Just a minute.
My lords can come to page 40.
Please listen to me.
Yes, Millers.
Let me just sum up for you because...
Oh, I'm sorry, Millers. I'm sorry.
This judgment and order says that under the facts and circumstances, considering the disputes raised, the pendency of the arbitration proceeding, and also the interest of the parties concerned, court is of the considered view that the writ petition cannot be allowed. And instead, it is hereby directed the amount due to be released as retention money by the employer should be kept in a fixed deposit in a nationalized bank
Right, Milos.
renewable periodically by the employer.
Right.
The amount so deposited, along with the interest accrued therefrom, shall be payable to the parties concerned
Right,
in
Milos.
terms of the decision to be arrived at by the arbitral tribunal.
Right, Milos.
All right.
Right,
So
Milos.
after this order was passed in that manner,
Right, Milos.
what has happened?
Milos, thereafter, Milos, there was when they had approached this honorable court, Milos, in 2024, there was a pending arbitration between the contractor and the subcontractor, Milos.
That's what I just read. So what
Yes.
happened after? Has it been
Thereafter, if my
concluded?
lords, as page 42, this is in settlement award.
42, yes.
And if my lords can come to the operative part,
Which
which
is?
starts from 45, Milos, the
Yes.
settlement agreement.
Yes. 45.
Yes, Milos. So this is a settlement that the contractor and subcontractor had entered into, Milos, based on which the award was passed. The important part is, Milos, on page 45 in the settlement agreement, point number 1, Milos. May I read, Milos?
Page number?
Page number 45, Milos.
45.
On the second paragraph, point number 1, may I read, Milos?
Yes.
It says division of retention money with authority and insurance money. The parties agree that the retention money due from the authority and which is lying with the authority and deposited in the fixed deposit in the bank as per the direction of the Gauhati High Court Aizawl bench dated 8th March 2024 in case number WPC 80 of 2022 titled JKM Infra Limited versus State of Mizoram and others shall be divided between the parties in the ratio of 25:75. JKM be entitled to 25% retention money lying in the deposit as on the date of the withdrawal, and APS shall be entitled to 75%, Milos. Right, Milos? So this was the settlement arrived at pursuant to my direction, my law's direction, and the award, Milos, which was pending when they had approached the honorable court. Now, if my lords can...
This 25-75% is between whom? The
contractor and the subcontractor, Milos. It is between the contractor.
The present applicant.
Yeah, opposite party number 1 is 25%, Milos, and opposite party number 2 is a 75%, Milos.
And what about the applicant? Oh, applicant is the state.
Yes.
Applicant was the state. Yes. Okay.
And after this, Milos, the important facts which I might not miss out, Milos, I must state right now here. After my lords passed an order, and during the pendency of their arbitration, there between the contractor and the subcontractor, opposite party number 1 invoked an arbitration against me, which was in September 2024, Milos, which was not there before my lords when they had filed the writ petition. Claim against me only came post passing of the order by my lords. On September, they invoked an arbitration.
What was the date?
14th September, Milos. 14th September 2024. I'll just give the date also, Milos. They invoked an arbitration and filed a claim of 377 crore, Milos, against me. It was on 17th September 2024, Milos. Now, so this is reflected. Yes, Milos.
That was not brought to the notice of this court.
Because it was not there, Milos. There was only an interstate dispute between the opposite party number 1 and 2. There was no claim. My lords, this is very important. There was no claim against me by opposite party number 1 or opposite party number 2. This claims only comes post passing the order and direction by my lords.
You are saying the date of the initiation of arbitration is September. Which date?
17th September 2024, my lords.
17th September 24.
Right, my lords.
Now,
I will take 1 minute, my lords. If my lords can come to page 46.
Okay.
And para 9, my lords. That's very important. How they have decided to flee the department is borne out from here. They settle, my lords, and now they want to basically defraud the department.
Okay. See, I have recorded these things in the order dated 25th of September.
Right, my lords.
In this IA.
Right, my lords.
You have a copy of the order?
Yes, my lords, I have a copy of the order.
So I have already recorded the facts which you've just stated.
Right, my lords.
And notice was issued. All right.
Right, my lords.
Now, one thing I would like to ask you is that
Right, my lords.
writ petition was disposed of with
Right, my lords.
certain observation and direction.
Right, my lords.
Yes.
Can you, okay. Thereafter,
Yes, my lords.
the arbitration came
Yeah.
to a settlement by passing of the arbitral award.
Right,
That
my
is
lords.
division of the retention
Retention money.
money in the ratio of 25-75.
Right, my lords.
The person holding that 75% has already withdrawn.
Right, my lords. Because yes, my lords.
As far as the 25%, that still remains.
Right, my lords.
Now, in the meantime, you now say that the subcontractor, is it?
The contract.
The contractor.
Okay, the contractor has initiated an arbitration case against you.
Right, my lords.
All right. And now you seek modification of the order passed by this court
Right, my lords.
on 8/3/2024,
Right, my lords.
which otherwise has already been acted upon. Now,
Yes.
such being the case,
Right, my lords.
what would be the role of this court?
Right, my lords.
Doesn't the principle of functus officio apply?
No, my lords. No, my
Why
lords.
not?
Because what my lords, the arbitration, I was not a party to that arbitration, and there was no claim, my lords. At that point of time, when there was an arbitration between, because the subcontracting agreement was between opposite party number 1 and opposite party number 2. I was not a privy to their contract, my lords. There was a dispute as regard between them with regard to the quantum of release. So that is how and there was no claim by either the contractor Milos or the subcontractor against me. I have released to the subcontractor Milos because they have given me an undertaking which is on page Milos. I'll just read, which is on page 53 that there is no claim against me. Now let them also give Milos. I'll release. Let the opposite party number 1 also give me a no claim certificate. I will release the money. It is subsequent event, Milos, when they invoked an arbitration against me in September 2025, which warranted the moving of this modification application, Milos.
No, that's why it's a subsequent event. So
Right,
where
Milos.
does the court come into picture now?
Yes, Milos. My laws can always modify. My laws have the power to modify under 151. Inherent.
How do
I
we
am only
modify
saying
an
till the
order?
pendency. I am only yes.
How do we modify an order which is already acted upon?
No. I have because.
Can we go back in time and say that no, it should be this way?
No, in view of the subsequent development, my lords can. In view of the subsequent development, because this was not the dispute before my lords at that point of time. So if there is any subsequent event, my lords, I have an inherent right to seek the indulgence of this honorable court. Because if the claim was there at that point of time, when my lords passed the direction, I would not have agreed to this, my lords, release. If there is a claim against me. Had there been a claim, because now opposite party number 2 has given me a no claim certificate, Milos, and now there is a claim against me when the opposite party has not even executed the work as borne out by my lord's order. He has not done an inch of execution in the project.
Okay.
Because they wanted to settle inter se between themselves, Milos, and take advantage of the PWD's coffers. They have moved this.
All right, Mr. Counsel, see, before we come to all those issues,
Right,
thing
Milos.
which I pointed out the other day was, is the notice affected from the parties concerned? Now,
Right.
it appears that somebody has filed a vakalatnama for the respondent.
Right, Milos.
So they perhaps may want to file an objection to your IA. We'll have to hear them also.
No, I have no problem, Milos. I am saying as the contempt proceedings are going on, otherwise my modification application would become infructuous, Milos. I'm only saying let them take no coercive action. Let them say that give an undertaking, they will not pursue for till the time the pendency of my modification application, the contempt. All I'm saying, because I don't want my officer, because I'm entitled, lawfully entitled to, Milos. And I will substantiate the Supreme Court judgment, which clearly says, even if the direction has been passed by this honorable court, this honorable court has the power to modify that order. And if I'm lawfully entitled to recover the losses, I can recover. I'll make that good, my lords. I'll satisfy my lords on the law and on the fact both. Otherwise, if I can't satisfy my lords can throw me. That's all. I'm only saying till that because I don't want this contempt issue to come in because they have given 6 weeks time to file reply. And I'm not in willful disobedience of my lord's order. I'm saying, Milods, I'm
You
willing to comply with this.
You file appropriate show cause reply to the contempt notice saying that you have preferred an IA which is pending for consideration, and pending such consideration, court may not proceed with the matter.
I will do that,
How
Milos.
do you expect this court to pass a stay order on the contempt
I am
petition?
not saying stay, Milos. I'm saying
An
this.
IA file
Yeah.
for modification of the earlier order.
Right, right. I am only saying, Milos, only I am requesting this honorable court that my lord's order and direction of 8th March 2024 be kept in abeyance till the pendency of the modification.
No, we cannot do that. You inform the court saying that we have filed an IA, so please wait for that outcome. You can do that.
Milos, then I'll have to file an appropriate IA in that stay application because court was aware. If my lords has my stay application, Milos, it's not that the court was not aware. If my lords has my stay
Let me
application.
just surprise your lordships because, my lords, certain submissions are being made. Actual facts are being kept in, my lords, in the dark.
Mr. Jordan, you are appearing for which respondent?
Respondent number 1, my lords, the main respondent, the contractor.
The contractor. Today is your first appearance, isn't it?
Correct, my lords.
Would you like to file any objection or anything to the IA?
Yes, my lords, it would certainly facilitate the proceedings. We'll be filing it by the end of today, my lords. Your lordships will give 2 days.
There are 2 IAs. One is for their modification, and one is for perhaps stay or something like that.
My lords, with regard to the stay applications, which my learned friend has referred to, my lords, we've not received it as of yet. But, my lords, we'll be filing the reply to the main application seeking modification.
Yes. How long? When you will file?
My lords, by end of day, my lords.
End of the day.
From the local council here.
Okay.
May I just apprise your lordships on one fact, my lords?
Today we'll do one thing. We'll give you time. That's it, and we'll fix a date.
Yes, my lords.
Beyond that, I don't think we can do anything today.
Yes.
Mr. What is your good name?
Ajoy Roy, Milos. Ajoy Roy, along with my colleague.
Mr. Roy, why don't you furnish a copy of the other application also?
I will do that. There was no notice issued, Milos, so that's the reason. I will furnish it today. By the end of the day, I'll serve it. That's not a problem. I undertake to do that, Milos.
Please write in IA 168. IA 168, you write. Mr. A. Roy, learned counsel, appears for the applicant. And Mr. Jordan Romingthanga, learned counsel, appears for the respondent number 1. And he submits that he may be given some time to file objection to the IA. What about the other, number 2?
Milos, I don't think they are basically performer. We have released the retention money in view of the undertaking given by them. So I don't think, Milos, they're proper.
No, but
I have already served them, Milos. I have already served them. That's all, Milos.
How you have served them?
By email and by registered AD as per my lord's order.
No, the acknowledgement report has to be there, isn't it? Just sending it will not suffice.
Yes, Milos.
Okay. Next para. Office note dated 7/11/2025 indicates that the notice sent to respondent numbers 1 and 2 have been delivered. After the postal consignment was tracked. To stop. In view of above, notice is accepted to be complete upon respondent numbers 1 and 2. List the matter again. Today is 11th, isn't it?
Milos, if they're filing a counter, if my lords can give me 1 week opportunity to file a rejoinder subject to my lord's permission, if at all, after 2 weeks.
List again on 20th of November, 2025.
Very well,
stop.
my lords.
The respondent number one shall file his objection by which date?
My lords, will be filing it by end of day, my lords. I've already sought to serve the local counsel here, my lord. We're here in the courtroom.
During the course of the day, as submitted by Mr. Jordan Romhingthanga, learned counsel, representing respondent number one. Stop. The respondent number one shall serve a copy of the same to the applicant, and the applicant may file a rejoinder to the same, if so advised, on or before the next date, with a copy to the other side. Right, list accordingly. Then the other IA.
Yeah, my lords, it is 195, my lords, for the stay.
Right, Mr. A. Roy, learned counsel for the applicant. Issue notice returnable by same date. What did I say? 28, not 28, it's 20. On returnable by 20 November 2025. Mr. Jordan Romhingthanga, learned counsel, appears for the respondent number one and accepts notice. Applicant to serve copy of the application to him during the course of the day.
Yes, my lords, I'll do that.
Objections, if any, may be filed by the next date. Applicant shall take steps for service of notice upon the respondent number two by registered post with ADD within 2 days.
We'll do that.
List accordingly.
Duly obliged.
All right.
Grateful, my lords. Grateful, my lords.
For admission, item number 1.
May I please, ma'am?
Yes.
Lordship, I'm appealing for respondent number 5 and 6 in this matter.
Yeah.
I'm yet to receive instructions, so if 3 weeks' time can kindly be granted, ma'am.
Okay. As paid for by Mr.
And I'm going
N. Angami, learned. You are senior
senior government.
advocate, appearing for the respondents for the 3 weeks' time
Yes,
is granted for filing counter affidavit as paid for.
I'm deeply obliged, ma'am.
For admission, item number 2.
Lordship,
Yes.
in this matter, I'm appealing for my colleague, Thiba, the Lordship.
Hmm.
He has some difficulties. However, I've been informed that the state is yet to file its counter affidavit.
Hmm.
So if 3 weeks' time can kindly be granted, my lord.
As paid for on behalf of Mr. E. Tibafon, learned government advocate, appearing for the state respondents. For the 3 weeks' time is granted for filing counter affidavit. List again after 3 weeks. Yes.
I have the same prayer for item 3 as well, my lord.
This is also your case or Tibafon?
Not Thiba.
2 and 3. These are fairly new cases, isn't it?
Yes, ma'am.
It's come for the second time.
Yes. Obliged, ma'am.